want to thank everyone for coming and for all of the hard work, both by the student organizers and in particular by Saul Sarabia for making this gathering possible. I want to also thank my colleagues from whom I continue to draw. They are my source of ideas, of inspiration, of sustenance in times of difficulty, of all things good, and I'm very, very pleased and honored to be here. This is an amazing collection of people that we hope will help us unpack some of the things that Kim just historicized for us, the way in which colorblind spaces are not just sort of the moment, but are in fact things that have existed over time and in different dimensions. I want to pick up actually on a theme that Kim ended with, which is the specific location in which we're in. That California in particular and UCLA in particular have been at the epicenter of the debate over colorblindness is not a coincidence. Colorblindness was not born here, but it has had many, many lives nurtured here. And the long and checkered pedigree of colorblindness reached its current iteration here in part in reaction to success. I mean, one of the things that Kim was talking about is the sort of different dimensions of reaction, or as a friend of mine from Mississippi used to say, the world is dialectical. And the point of that is simply to say that the reaction to UCLA's success, and particularly the law school's 30-year history of struggle over to desegregate legal education and to make educational access meaningful, had actually been a remarkable success. When I arrived 2 days after the adoption of the UC Regents resolution banning affirmative action in higher education here in California, what might be called the prelude to the kick being the subsequent enactment of Proposition 209 in 1996, there were over 80 black law students here at the law school and well over 120 Latinos. In fact, it was the most racially diverse law school in the top 20 in the United States. The graduating class, I believe of 95 or 96, I forget which, had no racial majority as between blacks, whites, Latinos, and Asians. Let me say that one more time. It had no racial majority. Within 4 years of the adoption of Proposition 209, however, the ground seismically shifted. And part of that was due to the legal mandate of 209, but it was also due to a set of choices that were made institutionally about adherence to an LSAT median as the sole and presiding definition of metric of merit. As a consequence, the enrollment of black students in the academic year of 1999-2000 dropped to 2 out of 300. Within that space, then, the entire population of the black students decreased from 80 to under 20. And as Kim has also reminded us, what this has basically meant is we have settled into crisis. And over the course of the years, the consequence has been that we have varied between 8 black students a year, maybe up to 13 or 14 in a particular year, but that has basically become normalized. The result for me in 1999 was what I can only describe as a particularly surreal moment, and it was a surreal moment which marked the space for me in a way that I hadn't thought about before, and it was when I was teaching constitutional law and Brown versus Board of Education to a class that had no black students. That was in the year 2000. The point is, of this sort of anecdotal account of the colorblind space is that the installation of colorblindness as a legal mandate in California over the past 10 years has created something of a living laboratory in which complex patterns of racial stratification have easily cohabited with formerly colorblind norms. We've had the development of a rich legal literature that has helped us understand, from a legal standpoint, a critique of colorblindness, and we've also had some demographic studies that have mapped out the shifts that I've just talked about. But we do not yet really have a full mapping of what colorblind terrain really looks like. So we want to begin this panel with what might seem like a rather obvious question, What does it mean to see colorblindness? What does it mean to see in a colorblind way? And if colorblindness is a space that we're trying to map, what are its dimensions, its boundaries, the features of the terrain? Is it the same across all institutional spaces? How does it appear through the lens of people who are differentially raced? How does something that is marked by its absence, that is marked by something that we ostensibly do not see, manifest itself? So one way of bringing what might sound like a bunch of theoretical questions to ground, but again, as I said, this is ground zero in a way. These are not theoretical questions here. Is to try to is to ask, what would it mean to try to operationalize colorblindness? What would it mean if we actually tried to see in a colorblind way? What would this mean? Well, in a recent work with my colleague Devin Carbata, we tried to raise this question of how colorblindness might actually work in the context of, say, for example, writing a personal statement when one is applying to a college or university. So we construct a personal narrative drawing on none other than the figure that looms in the background in many respects over our conversation here. And we draw on a number of public figures, including President Obama, to ask a question of what his personal narrative might look like were he applying to college or university. And we draw from his autobiography, Dreams from My Father, to extract the following personal statement. When people who don't know me well, black or white, discover my background, and it's usually a discovery for I cease to advertise my mother's race at the age of 12 or 13, when I began to suspect that by doing so I was ingratiating myself to whites, I see the split-second adjustments they have to make, the searching of my eyes for some telltale sign. They no longer know who I am. Privately they guess at my troubled heart, I suppose, the mixed blood, the divided soul, the ghostly image of the tragic mulatto trapped between two worlds. And if I were to explain that no, the tragedy is not mine, at least not mine alone, it is yours, sons and daughters of Plymouth Rock and Ellis Island, it's yours, well, I suspect that I sound incurably naive, or worse, I sound like I'm trying to hide from myself. So we ask ourselves, so what would it mean to try to see or perceive this story in a colorblind way? What would it mean to sort of racially cleanse this story? So we tried this. So here it is, our first sort of cut at racially cleansing it. When people who don't know me well discover my background, it's usually a discovery, for I cease to advertise my mother's identity at the age of 12 or 13. When I began to suspect that by doing so I was ingratiating myself, I see the split-second adjustments they have to make, the searching of my eyes for some telltale sign. They no longer know who I am. Privately they guess at my troubled heart, I suppose, the divided soul, the ghostly image of the tragic person between two worlds. Well, now, what does this now mean? It's hard to tell, except one might suggest that this suggests a rather troubled applicant. Someone who one might want to put to the side in that category of files that goes for extra consideration. Partially because a story about being torn between two worlds and about being self-reflective about that now sounds a bit paranoid. The point of the exercise is simply to demonstrate that the challenge of actually what it means to see in a colorblind way. Presuming that we don't know all that we need to know, and of course that is true, our panelists are going to help us explore the question of what seeing colorblindness actually might mean. And I'm going to introduce them in the order in which they're going to speak. And then at the end, we're going to ask them to engage each other for a moment before we turn over the questions to you. So I'm going to begin with Neil Gotanda. As Kim just acknowledged, Neil is one of the founders of critical race theory. Of course, Neil and I might mention that, at a certain point you reach an age where you don't want to be identified as the founder of anything. So rather than call him a founder, I'll call him an intellectual architect, which he indeed is. And his work, A Critique of Our Constitution as Colorblind, remains ever generative of powerful insights, many of which ground our discussion here. Our second speaker will be Kevin Reed, who is Vice Chancellor of Legal Affairs. He's the lawyer's lawyer. He's the one that we call when we need help. And after a successful career as a civil rights attorney at the Western Regional Office of the NAACP Legal Defense Fund, he successfully sued the LAUSD, and because he successfully sued them, they wisely hired him as their general counsel. But he left there and has been here since 2008, helping the school navigate the troubled shoals of anti-discrimination law and educational access. Following Kevin will be Denise Sekaquaptewa. She is a University of Michigan psychologist who's doing highly influential work, particularly germane to our conversation here. She studies group dynamics and the effect of stereotyping, and particularly poignant for me in Denise's work is her study of minority status under extreme conditions of minority status when there's only one. What's the solo status experience? That's what I'm trying to do. Following Denise will be Evan Apfelbaum. He joins us from Tufts University. Evan is a premier example of how to hit the ground running. Although he's still something of a newbie in the profession, his work on intergroup relations and strategic colorblindness has already been published in major journals, earning him a recognition as the Early Researcher Award from the American Psychological Association. And finally, last but certainly not least, our colleague Gary Blazey, who is also affiliated with the Public Interest Law program here at UCLA, as well as the Critical Race Studies program. Gary is one of the premier examples that the canard that there is an unbridgeable gap between theory and practice is wrong. Gary is both a leading public interest lawyer in the state, known for his work on issues of homelessness, but equally powerful work on the intersection of law and social cognition. And so with that, I'm going to turn it over to Neil.
Thank you to Cheryl. Thank you to all of the members of the Critical Race Studies department, I guess, that have put together this really quite wonderful experience. I was suggested that I go first, and that's always daunting. It's especially bad since one of the themes that speaking at a conference is never follow Kimberly Crenshaw. That goes without saying. So be prepared to be a little disappointed. But I am going to talk about the structural elements of colorblindness. I'm going to draw extensively upon that 1991 article, A Critique of Our Constitution as Colorblind, since I tried to lay out some of the parameters of constitutional colorblindness. And in some of our discussions and comments about trying to understand the way in which colorblindness works in the notion of race in colorblind spaces, I began to sort of recast this in just in a slightly different format. I'm going to here address the Harlan dissenting colorblind constitutionalism context. That is a particular tradition, and the contrast to that will be the part of my concluding comments here. So, in this trying to sort out these notions, I'm going to draw upon three considerations: one, multiple usages and meanings of race; second, the public-private distinction; and three, racial non-recognition. So I argue that race, first of all, even in constitutional law, does not have a single meaning but multiple meanings. And the key idea here is formal race. That is to say that formal race categories are those in which one recognizes race by making reference to the named category, black or white. And in its treatment, this kind of formal race category is a necessary prerequisite to giving jurisprudential coherence to most of the constitutional and statutory legal treatments of race. So I take formal colorblindness, as used in the conference call in the introductory materials, to be a reference, first of all, to the use of formal race categories as one of the key identifiers of race and racial practices. Now, the implication of formal race is that other non-formal race considerations, language, religion, socialization, nationality, popular culture are separated and divorced from that, from the notion of race. They are not included within the formal race categorization, and in the legal tradition, under constitutional colorblindness, any such considerations must be separately demonstrated affirmatively to be linked to the formal race category. And this is the particular and peculiar treatment. In the 91 article, I made reference to, for example, culture race. Just the notion that race is culture is presumptively not included in the formal race category. Similarly, historical race, an historical race narrative about slavery and the legacy of slavery is not included in the formal race classification. Now, turning to the public-private notion, to examine a domain, in our call for the conference, we talked about university, workplace, policing, and self-governance for very different kinds of contexts. As marked by formal colorblindness, I note that this can have multiple understandings. In the constitutional colorblind tradition, there are two distinct understandings, one for public legal space and another for private legal space. In the public legal space, dominated by Supreme Court interpretations, the Supreme Court has applied its peculiar constricted doctrine of strict scrutiny. So in public space, and this is the state action doctrine where there is governmental action is present, we have been reduced under the strict scrutiny notion in recent interpretations by the court to discussions of a microanalysis of college admission standards. So instead of discussing the notions of justice and fairness in the context of race in American history and society, we're down to whether or not you can use points in an admissions context. And so that sort of the constitutional discourse as led by the Supreme Court has led us into this particular narrow, it seems to me, dead end. But in general, in public space, any use of a formal race categorization will trigger strict scrutiny and therefore will likely be found impermissible. In private legal spaces, the starting premise is that there is a private right to discriminate, modified by statutory prohibitions on racial discrimination. So in private spaces, the presumption is you're not discriminating until A, there is a statutory prohibition, and then B, the burden, as always, is upon the petitioner to prove that there has been discrimination. So the dominant model to interpret such statutes is the anti-discrimination model, in which the non-discrimination is the norm and discrimination is aberrant behavior. The starting premise of the anti-discrimination model is therefore a domain in which race is not an element. The presumption is that it's not present, that discrimination does not take place, and therefore not considered, but the insertion of race into the private context is therefore somehow an impermissible and unlawful insertion into an otherwise presumptively non-discriminatory and, in this sense, colorblind space. So such aberrant behavior may be legally addressed by showing discriminatory intent or creation and maintenance of an improperly raced social context, the hostile work environment. So these are the different kinds of treatments in the public and private domains: strict scrutiny and anti-discrimination, and in the public domain, and anti-discrimination in the private space. The last topic I wanted to address is the notion of non-recognition. And here I suggest I titled this part of the discussion, my discussion, as non-recognition as technique. That is to say, in order to claim that someone is colorblind and does not see race or does not consider race, and my standard example is the classic discussion, oh, we had a black applicant today, but I didn't take that into consideration. There's three elements that are involved in that. First, there must be something which is cognizable as a racial characteristic or classification, the formal race recognition. Second, the characteristic must be recognized. There's a psychological notion of recognition. And third, the characteristic must not be considered in the decision-making process. So for the non-recognition to make sense, it must be possible to recognize something while not including it in making a decision, a separation of the two processes. Non-recognition is therefore a technique, not a principle of traditional substantive common law or constitutional interpretation. It addresses the question of race not by examining social realities or legal categories or constructions, but by setting forth an analytic methodology. This technical approach permits a court or anyone else asserting non-recognition to describe, to accommodate, and then to ignore any questions of subordination or context. This deflection from the substantive to the methodological is significant because the technique appears purely procedural. Its normative substantive impact is hidden. Colorblind application of the technique is important because it suggests a seemingly neutral and objective method of decision-making that avoids any consideration of race. So these are some of the elements of our Constitution as colorblind Harlan dissenting tradition, which is referred to, it seems to me, when one speaks of colorblindness. Now, there is a different tradition. There is a different tradition of colorblindness, which it seems to me is encapsulated in the Martin Luther King, what has become folk wisdom. We should not judge someone by the color of his or her skin. Now, since I'm convinced that Martin Luther King never forgot that he was black, there's something really complicated going on here, right? That this is part of a genuine search for trying to accommodate and understand how one can judge and provide for merit and understanding in the context in which one is not supposed to consider some dimension of race. Now it seems to me a very powerful and noble tradition, something that we should encourage. But both of these, Harlan and King, are referred to as colorblindness. There's something very problematic here that's going on. And so to summarize and close on this, I refer to the what has become, at least in some circles, in a Prop 209 space, the manner of the way discussions take place in a hiring decision, for faculty in particular. And the rule is, first person to mention race loses. Okay. So if you're an advocate, you know this person is a candidate that you'd like. It's a person of color, brings desirable understandings of sexual orientation and women in the context of society, but you never mention it. Right? And on the other side, right, it's the same. If that person says it's an affirmative action hire, you're using race, that side loses. Right? Because you can say, no, I'm only talking about the merits. You've invoked the race card. It has its corollary in, he's gone, Obama, right? So the Obama story is, of course, during the elections, this, first person to mention race loses was part of the discussion. There was all this back and forth. You've invoked the race card. No. It's the Republicans were charging the Obama campaign and vice versa. It was not invoking race in some tradition, in the old-fashioned way. It was rather first person to invoke the race card loses. Now, the problem in the investigation is both of those represent colorblindness. If you are trying to get your candidate, a progressive candidate that you feel is going to make a contribution hired, you don't mention race. Is that colorblindness in the way that we've discussed? And if we're investigating unconscious racism, invoking what's going on in one's mind, investigations of racial profiling by the police, uncovering race, is one project, but invoking the notion of what goes on in progressive, trying to hire a socially sensitive candidate also means hiding race in a Prop 209 workplace is difficult and problematic.
Thank you. I feel very much delighted to be here, although a little surprised to be here. I'm here as a practitioner, and I feel like I came to learn much more than to teach, but delighted to have the opportunity. And I really came to share more a question than an idea, and I'm going to focus on my experience since I came to UCLA a year ago with undergraduate admissions and underrepresented minorities here at UCLA, admittedly a very narrow topic. I was delighted to hear Professor Crenshaw's statements earlier, and I had to take note of her one quote, because I'm delighted to have, not just as my goal, but now as my job, the ability to try and eradicate the phrase 209 made me do it from UCLA. And I think that I actually have clients who are anxious to find ways of eradicating that from the vocabulary here at UCLA. I do want to give you three caveats. One, because the issues that I'm discussing right now, I strongly suspect will end up in litigation sometime in the next couple of years. I want to make it very clear that I'm talking as an individual practitioner and as a lawyer thinking about these issues, and not as UCLA. Second, I will be focusing on issues relating to African American admissions, or at least that's where my data largely come from. And third, that I am focusing on the very narrow issue of the decision making here at UCLA in the undergraduate admissions realm when making decisions about admission of students who have already made it this far. And the students who have already made it this far is a desperately small pool when you're talking about African American students. There's clearly not color blindness when you are talking about the social construction that creates the pool of students in the state of California, or who apply for admission to the University of California, who have made the A through G, met the A through G requirements and are otherwise even eligible for admission to the UC. And I'm not going to attempt to address, how those numbers got as pathetic as they are. I'm dealing with really just where we are with respect to that pool of candidates who make it as eligible for admission to the University of California, Los Angeles. Set the stage somewhat. UCLA currently has more applications for undergraduate admission than any other university in the nation. This year and last, 56,000 students sought admission to UCLA. We admit about 12,500 students and expect somewhere in the neighborhood of 40 to 45% of the students to accept admission into the freshman class. It's an enormous process. It involves hundreds of people. As we speak, there are 165 readers who are going through applications and making decisions. Every application gets 2 reads from 2 independent readers, and determining who is going to be admitted. Just to give you the rough numbers, African American students, African American applicants make up about 2,000 of that 56,000 applications for admission. In the state of California, graduating from public institutions in the state of California, last year there were only, according to state statistics, about 1,600 students, African American students, who graduated eligible for admission to any UC, that is statewide in the state of California. From what we can tell, we get almost all of them seeking admission to UCLA, something that folks at the university are very proud of. The issue is, once they've applied, getting them competitive for admission and the decision-making process of their admission. 2006 was the nadir for admissions here at UCLA when it comes to African American students. Again, giving you out of 56,000 applications, about 2,000 of those African American. In 2006, approximately 200 African American students were offered admission to UCLA, of which slightly less than 100 actually accepted admission. So we looked at a post-209 world, although 10 years past the passage of 209, in which you had the specter of less than 100 African American freshmen in the entire UCLA campus that fall. That did prompt an examination of the admissions process and the adoption of a different admissions process, one that is called holistic, that tries to have each of 2 readers look at each application within the context of all of the record of a student. The net result has been a market improvement, although within the numbers we're talking, not a spectacular success, in which last year about 450 African American students were offered admission in the freshman class for the fall of 2008, of which just over half accepted admission. So we've doubled the numbers from, more than doubled the numbers from 2006. That prompted a backlash from the right, and a professor here in the political science department released a report shortly afterwards claiming that we were cheating. That there was, in his estimation, a growing body of evidence that UCLA was violating Proposition 209. And his evidence that we were cheating was the fact that we had admitted twice as many African American students in 2008 as we did in 2006, coupled with his belief and his theory, his thesis, that because we allow students to write essays, and they put in, such as Professor Harris put up there, they get to put on their essays, their personal experience that African American students must be cheating and identifying themselves as African American in their applications. He has sought from us copies of all of the, actually he sought a subset. The Pacific Legal Foundation subsequently sought every application for undergraduate admission at UCLA for the last 4 years. Before asking them where they would like to park the semi, we suggested that maybe privacy rights said that we couldn't do that. We're in negotiation with Pacific Legal Foundation about what data we will give them. That said, what we got from this professor and from his colleagues was a pretty simple thesis, and that is that if people are cheating in their essays, that's allowing the admissions officials to put their thumb on the scale, violate 209, admit somebody because they're African American, not because they have merit. What I found very interesting in this professor's critique is he put out there that he believed that it must be happening because he himself would do it. He described his own daughter's background as being part Scandinavian, part Native American, and some other nationalities mixed in, and posited the fact that if he saw an application for admission that involved a part African American, part Scandinavian, or part Native American, part Scandinavian, he would, of course, favor that application, which has really caused me to sit back and say, is that refreshing or is that horrifying? Maybe that's just a recognition that we do not live in a colorblind space, and he's actually bold enough to admit it out there. In the meantime, what does it mean when we know that I've got an application process that I suspect I will be have cause to defend in court in the next couple of years, and believe very strongly that we're following the law and will continue to follow the law. But part of what we say in our process as we train these 160 readers is do not take into account the race or ethnicity of the applicant whose application you're reviewing. What does that mean is the basic question I bring to this conference. How do you ask somebody to do that? And I think that Professor Carvana and Professor Harris have really raised that question exquisitely well in their piece in the Berkeley Law Review. And at the end of the process, I guess the question I'm asking is whether, in fact, what 209 is allowing us to do is to break beyond that barrier and begin to think about things like admission to undergraduate schools as being more than by the number. It allows us to abandon a false sense of merit that an LSAT score or an SAT score or a GPA is the measure of merit, and that an affirmative action program that simply fudges those numbers in order to allow a certain number of underrepresented minorities to achieve admission at the end of the day is, at the end of the day, nothing more than protecting that strange meritocracy, which maybe didn't deserve defense in the first place. And then what we're being forced to do in our process is to think very carefully about what it really means as a public institution to admit the people who are going to do the best at University of California, Los Angeles.
Hi, I'm Denise Sekaquaptewa from the University of Michigan, and I'm a social psychologist. I do experimental research that's related to issues of diversity and race, in terms of race and gender, and some in terms of socioeconomic status. So my research is related to diversity and to lack of diversity. So what it's like to be in an environment where there are a few other people like you. So if you consider the experience of students, an African American student who enters a classroom and they're the only black person there, probably some of you have experienced such a situation where you come in and there's nobody there of your particular social category except yourself, be it gender, race, or something else, another identity that's important to you. The research suggests that that can be a negative experience for people, can have some negative consequences for them in academic settings. And of course, the issue of colorblind policies is relevant to that because if, let's say, affirmative action policy or taking away affirmative action does result in fewer racial minorities being accepted to a university, then the people who are there, who are ethnic minorities, will be more likely to experience the situation of being the only one of their background in that particular setting. So beyond that issue, though, of being of underrepresentation in settings that lack diversity, I also study situations where it is a more diverse setting. There's chances to interact with people from other groups, but that represents its own challenges, right? Whereas people struggle to learn how to communicate and overcome fears of prejudices when talking across racial lines. So I think I will first talk about the research that's relevant to lack of diversity, and then I'll talk more about interracial interaction research. So in the first set of studies in my research on the lack of diversity, I focused on the situation of solo status, and that's where, as I mentioned, you're the only one of your social category present in a particular situation. So that is the only black person in the classroom, the only woman in her engineering study group. Okay? So these are common experiences for people who are from racial minority groups simply because of their lower representation. Now, I think that when that situation happens, when one finds a setting where there's only one racial minority person, it's easy to suspect, well, that person's there because of some affirmative action policy, and that's why that accounts for the reason they're here in this particular setting. But our research that we do in our laboratory setting shows that these effects that I'll talk to you about emerge even when that isn't a factor, even when one just happens to find themselves in a setting, in a group, where I'm the only person of a racial minority status. So it doesn't have to do necessarily with being particularly selected to be present because of your racial minority status, but also these things happen that probably exacerbates it, but it can also happen in the absence of that kind of information. So in our lab, what we do is we bring in undergraduates and put them in situations where they are either, for example, the only black person in a testing group of whites, similarly the only white person in a testing group of blacks. We do the same thing with gender, and have them do a variety of tasks in this situation and answer questions about their experience. And the results show that the racial minority students on an oral exam task where they have to sort of stand up and answer questions in front of an all-white audience do worse at that task in terms of their the accuracy of their performance compared to groups where there are other black people present. So when you're in that solo status situation, it's more negative for these students. The same thing happens for women who have to perform in the context of an all-male group. Okay? But it's interesting that the opposite doesn't hold. That is, for white students in front of a group of a black audience won't show that same underperformance effect compared to if other white students are there. Similarly, men do just as well speaking in front of a group of women as they do as when other men are present. So I think it really has to do with a perceived discrepancy between the status of your own group that's salient, that's sticking out in this situation, compared to the others. So women and blacks underperform in the context of men and whites, but the vice versa doesn't hold. We also see evidence of different psychological pressures that that these solo status people experience. So feeling pressured to represent one's race, right? So feeling like if I screw up this task, it's going to look not bad just for me, but for us, for everyone who comes along like me. So it's like carrying kind of like feeling a burden, I think, of having to represent not just yourself but your group, and that certainly is a lot to bear, I think, for people who are in that situation. We also have done, as I mentioned, I've done these studies in race and in gender. We also did some recent studies with socioeconomic status to address the issue of people who are from lower socioeconomic backgrounds coming to university where there's a lot of people who are not from that background, who come from families of money, and how the stereotypes around status, socioeconomic status, can also affect their experiences when those statuses become salient. Of interest, that interacts with gender. Men and women respond differently to socioeconomic status salience, but I won't go into all that right now. But it's interesting work, and what I think is important about it is that we can directly compare performances and experiences of racial minority people in situations where we can actually manipulate their immediate group composition. So how do they do when there are other people like them, when there are other black people there, compared to when there are 0 other black people there under these experimentally controlled conditions? Turning to my research on interracial interaction, certainly a benefit of diversity that people talk about is the idea that you can talk with other people and learn from them and from their experiences, and they can learn from yours, and that should happen across racial lines. I think there's, well, in my research there's a couple of processes that I see that can kind of diminish that ideal outcome, right? And certainly, implicit biases are something we've studied a lot in social psychology, and is emerging. People have them when they're not aware of them and don't necessarily want to hold them, and that they can influence people's nonverbal behavior, their subtle behaviors that they enact towards members of other groups. So in laboratory situations, we find that whites who hold implicit stereotypes about blacks actually show subtle negative nonverbal behaviors and interactions with them in the lab, both structured sort of interactions as well as very loose, let's play a tic-tac-toe game together interaction. And that the black partners can pick up on that and come to not like these implicit stereotyping whites as a result of that subtle nonverbal behavior that they're showing. So it's, that's one way I think that even among people who really strive to be egalitarian, I don't want to be racist and I'm not racist, I don't hold those kinds of beliefs, to the extent that they can have them at an underlying level, and that they can taint their nonverbal subtle behaviors towards people, not making eye contact, turning subtly away from them, when they're interacting, and that they don't know they're doing that. As certainly interracial interaction is tainted in that way by this unintended stereotyping. Finally, in some other studies we've done on interracial interaction, we found that participation in interracial discussions about race differs by the race of the participant, of the race of the interactant. And this was motivated by my experiences as an instructor. I certainly teach about in courses where topics of race come up. And I noticed that when they do, the participation of students of color increases, whereas the participation of white majority students decreases. All right, so all of a sudden, the white students have less to say, and the students of color have more to say. So we examined this in an experimental situation, and by forming groups that either vary by racial composition, half black and half white, or that don't, and they talk about topics that are either race relevant, segregation on campus, affirmative action, or race-irrelevant topics. I think we picked human cloning last time. We were trying to find things that didn't seem like they could be relevant to race. And then we find that evidence of that the black students tended to fall into a teacher role, that is by talking more and imparting information to others when they were talking in an interracial group about race. Whereas whites tend to fall into a learner role, where they tend to take in information and try to listen to the stories of others rather than putting forth a lot of their own information. And that these roles that students fall into are related to factors such as the stereotypic expectations we hold about blacks as whites, as blacks as being sort of race experts, whereas whites as having less to say, less experience talking about race. And I think as Evan's work may talk about that, actually there's a perception that whites shouldn't be talking about race, so that also is something that inhibits their participation in interracial discussion. But certainly that bodes negatively for people learning from one another about race if their participation in interracial discussions about race is so unbalanced. So in closing, I guess, I think the issue, the question in regards to colorblindness about all of this is that in settings where color, race isn't supposed to matter, do these processes still emerge? And of course I think the answer would be yes, because certainly at Michigan race isn't supposed to matter anymore, but you can still do this kind of research there and see this kind of outcome. But I think that a lot of it is things that we pick up from society, the race, the expectations that people know more or less about race depending on if you're black or white. The subtle implicit stereotyping we pick up from society, all of that is in the world, and just because you go into a setting where it's not supposed to matter doesn't mean that it doesn't matter anymore. So, thanks.
So I'm going to talk about a stream of research that I've been working on that contributes to sort of our understanding of colorblindness, but really talks about colorblindness in a different manifestation, and a manifestation specific to social interaction, a strategic approach to social interaction in which race may be a relevant consideration. So I'm going to start with what is sort of the trajectory of how I began to become interested in these issues, and it starts from a very simple anecdote at a sort of individual or a micro level, and what I'll close with are my most sort of recent thoughts and directions that I'd like to pursue, which really speak to larger sort of macro societal issues. So I became interested in these issues by looking at a large body of evidence, converging evidence, suggesting that we're living in a world, a social world that is increasingly multicultural. Whether we're looking at demographic trends in the redistribution of the population in the United States, or the increasing number of domains in which race is considered, these general shifts, these increases, excuse me, in the these increases in diversity were well chronicled and well studied, but we knew far less about how individuals have begun to respond to these changes, and specifically what were the specific intuitions and interaction strategies that individuals brought to the table when such considerations, when they faced these encounters with individuals of another race or about topics in which race may be relevant. And one approach that I noticed early in running these studies is that some individuals seem to hold this belief that by not talking about race or even pretending that they noticed race, they could somehow steer themselves through the interaction in a way in which they'd be viewed more positively, particularly appear less biased. Now, this has maybe take the form of describing a new guy in the office as the bald guy with glasses who wears a sweater sometimes who's black, and or a Stephen Colbert satirizing, wait, are you a black person? Because I don't even see race. I just see silhouettes and shapes. Something like that. So clearly these are anecdotal instances, but looking more broadly at the literature in legal domains, educational domains, political domains, this was an emerging approach, strategy for dealing with issues in which race was relevant, and particularly among white Americans. So in looking at psychological literature, what was very clear at the outset was, well, the notion that somehow we're actually colorblind perceivers, not well substantiated by the literature, it turns out. We see race in most cases in less than 150 milliseconds. So at a very basic level, the notion that, again, we don't see race doesn't seem to be well supported. But what I found out later on is that this decision to acknowledge as much, to acknowledge that we're perceiving race, seemed to be a strategic one. I'm going to quickly describe one paradigm that I've used to look at this to try to provide a concrete, more tangible way of looking at this notion. Picture yourself sitting in front of a large set of photographs, say 30 photographs of people. Now these photographs vary in a wide variety of ways, but importantly, excuse me, half the photographs are of white individuals and half are of black individuals. And what I tell you the instructions are, I want you to use the fewest number of yes-no questions that you possibly can in order to figure out the single photo that I'm holding. Now, if a gun is placed to your head and all you care about is performing, you should ask about race, right? Because that's immediately going to eliminate half the photographs. Now, it turns out that in the laboratory, it doesn't always work that way. So the initial studies we did, we manipulated who white participants were playing this game with. White participants played either with a white or a black confederate, a partner. What we found is that the tendency with a white partner to mention race was around 93%, dropped all the way down to 60% when they're interacting with a black person. In another iteration of the study, we found that if the black person, the partner, was the first one to ask questions about this array, and then the white person followed suit by playing the game, when the black person mentioned race, whites followed suit by talking about it 95% of the time. Yet when they decided to not talk about race, this dropped all the way down to 10%. Now, this is particularly interesting when you consider the context. We're talking about what is basically modeled after a children's board game. So we're probably underestimating the actual sort of power of these effects in a more contentious environment, for instance, where allegations of racism are considered. So that's the practice of it, right? Let's look downstream at some of the consequences of this. Is colorblindness an effective strategy at eliciting these positive outcomes? Is it effective at shielding whites from others' attributions of bias? Well, the short answer is no. And what we found is that there are a variety of costs, ironically, associated with this. In one study, we took whites who were playing this description task. We took videos of them as they were doing this. We cut sound and brought in naive observers to watch these videos who knew nothing about the study, not that it had anything to do with race or anything else, and just rated how friendly these people appeared. Those individuals who acted colorblind or avoided talking about race were rated as less friendly. In a subsequent study, we brought in black observers we explained the instructions of the game, and we said, I want you to guess, this is a study on guessing personality dimensions of other individuals. Make a snap judgment. Guess how prejudiced you think this individual is. The people who avoided talking about race were actually rated as more prejudiced than those who simply acknowledged race in this setting where race was relevant. And so this brings in this ironic element whereby these individuals who are engaging in this colorblind strategy, those are individuals particularly motivated by these politically correct concerns, yet are acting in the very way that is eliciting these negative perceptions from black interaction partners. I have a couple minutes left, and so I'm going to jump ahead to what I've done since then. And one of the interesting things that that I've asked, I believe, one of the interesting questions since then has been, well, where does this come from? Where do these misguided intuitions about how to navigate race-relevant situations come from? And we've looked at specifically the process of human social development and when it is that children begin to develop these intuitions about how to navigate race-relevant situations. This points to a very practically important point to plan intervention strategies. And we know that children from 3 to 6 months of age can already perceptually discriminate between individuals of different races. By age 5, they have knowledge of some social stereotypes and can accurately label individuals based on their racial group membership. But somewhere down the line, they learn that by applying these same principles to describing other individuals based on their skin color, they might risk appearing politically incorrect or biased. And the question was, well, when do those sort of concerns emerge? And what we find is that it's somewhere around 10 years of age when these concerns emerge. And the way that we do this is we give this exact same task, this photo description task, to children who are 8 and 9 years old and 10 and 11 years old. And what we find is that in a rare instance in developmental psychology, these 8 and 9-year-olds are actually beating the older kids. They're using fewer numbers of questions than the older kids because the older kids have just basically stopped talking about race, and they're believing that this is the culturally sensitive way to interact. And so I'm going to leave you with a couple thoughts, particularly some would suggest that this broad emergence of a tendency to not talk about race is undeniable evidence of progress made towards social equality. I mean, this is evidence that race doesn't matter anymore, right? That certainly is, something that there's a lot of evidence here to suggest. There's a lot of evidence here to suggest otherwise, and I'm going to ask the question sort of more broadly. To the extent that children and adults are practicing this, are we getting any closer to this ultimate egalitarian endpoint? Are we sort of in a blind pursuit of social equality? And if nothing else, the fact that this is so broadly endorsed by children from 10 years old really gives us a sense of a taste of what's to come. If we think that colorblindness is prevalent now. I can tell you from being in public elementary schools in and outside of the Boston area, a variety of them, that this is how children, administrators, teachers are sort of espousing ideologies about how to deal with race, and this is really a taste of what's to come. So I'll just end there.
My name is Gary Blazey. I teach here at UCLA in the law school. Listening to Evan and Pat reminds me why I much prefer reading the science journals to the law journals. For one thing, the articles are much shorter and they generally include such remarkably creative experiments. Before coming to academia, I was a lawyer and a public policy advocate for 20 years in Los Angeles, and to some extent my perspective remains the same. To use a medical analogy, I'm quite interested in diagnosis, but to me the most interesting questions are treatment, especially when the subjects of that treatment are what doctors call treatment resistant, and when the subjects of that treatment include me and ourselves. There's a lot more work in the academy, both in the law schools and in the labs, on diagnosis than there is on treatment and intervention. And there is some suggestion from our scientific colleagues that we just don't know enough yet to suggest interventions, or we first have to get the basic science down a little better. And my response is that we should use what we think we know, because it's generally probably going to be more accurate than what we assume to be the case, what sort of folk knowledge or folk psychology is. So let me give you a concrete context where you just don't sometimes have time to wait for the science to answer all the questions. California's first anti-discrimination law was passed 50 years ago this year, which means this is an anniversary year, and the way things work, that means there will be legislative hearings to revisit the subject. In response to that eventuality, the director of the State Department of Fair Employment and Housing asked us to look at her agency, top to bottom, 360 degrees, let the chips fall where they may, and the laws they enforce, and to suggest how they could be improved, basically how we could bring the anti-discrimination laws in California into the 21st century. And to back that up, she gave us access to all of her staff, all of their data, and we've been working on it ever since. Now, looking at the data, interviewing people, there are some reforms that are sort of obvious. For example, the statute describes or bars discrimination based on sexual orientation, but only mentions gay people and bisexuals as being capable of being discriminated against on that basis. The larger questions have to do with the effectiveness of the entire apparatus, and so you come down to really sort of practical questions. So how should the kinds of discrimination that give rise to liability, how should they be defined, and at what level? Should we just be looking at individual decisions that result in discrimination, and in that context should we drop the intent doctrine, and if so, what should we replace it with? Or should we be shifting our focus from individual decisions and looking more at organizational structures and environments that we know tend to enable or promote discrimination? In a world of scarce resources, are there ways that we can sort of prioritize where our resources go? Can we use social scientific methods to identify sites where discrimination seems to be more prevalent than other sites, rather than just responding to complaints? So to go back to the point about the role of science in this and the nervousness of science about we practitioners stealing their stuff and trying to apply it, the practical question is always as compared to what? And again, California, like every other place in the federal law, basically assumes that discrimination only involves conscious, intentional discrimination. And whatever we know about how discrimination works, we know that that's not right. We know that that's not the complete story. So that's a sort of a point of departure. So assuming that's right, that we then come to the focus of how do we go about winning the hearts and minds of enough people to actually change how we look at these issues. And so continuing with this issue of the intent doctrine and the assumption of conscious discrimination, people have been struggling with that in the legal academy at least for about 10 years or more. Hundreds of law review articles now talk about it. Not a single federal case, not a single state case even so much as mentions it, which is an interesting fact about which there could be many explanations. But one of them I think may have to do with a more fundamental understanding that people tend to have of what it means to discriminate. People do not like to punish practices or behaviors that do not result from some conscious intentional decision. They're willing to award consequential damages for negligence and that sort of thing. But if you have a tort-based, deterrence-based model, you need to be able to punish beyond the actual damages. And if people are, according to what people in the field of what I call the psychology of blame, seem to think quite resistant to doing that, what does that mean for us? And it also means what do we do about shaping that system? So one possibility would be to reserve the tort model, the deterrence-based model, for the instances of obvious conscious intentional discrimination. And here I would use the analogy of environmental law, where we punish point source polluters under the tort model, but there's also a regulatory scheme that requires businesses to adopt so-called best practices to avoid environmental pollution or, by analogy, racially discriminatory practices. The problem here is that in this field there are no well-established best practices. What we do know is that the practices that people actually do, the sort of diversity training things, are at best ineffective and according to some experiments, counterproductive, producing a sort of a backlash effect. Second, or third, wherever I am in my list of points, I only have like bullet points, so this doesn't actually work. I think the defense of colorblindness and of the intent doctrine probably involves some of the same psychological processes. And this has to do with stereotypes of a different kind that don't get studied much. We have a lot of knowledge about stereotypes of underrepresented minorities, women, sort of out-groups according to the white model. But we don't have many studies of stereotypes of what it means to be a racist, what that means, what that term means to people, or what it means to be a person who discriminates. And my intuition is that we have a stereotype of discriminators that really has persisted since the Bull Connor, police dogs, fire hoses era of the civil rights movement. And for most white Americans to be accused of being a racist or to have that concept raised basically causes them to evaluate whether they are like Bull Connor, whether they are morally inferior, whether they are evil. And frankly, you don't need a lot of experiments to show that people's basic defense of their self makes it very difficult for anybody but psychopaths to accept the fact that they are evil. And therefore, colorblindness is a way of just avoiding that conversation, and it has the consequences that Evan talked about. It's not very effective, but it stops the conversation at a certain point, at least for white people. And we may not all be cowards when it comes to talking about race, as Eric Holder said, but extraordinary bravery is also fairly rare in every population. And here I think the science can be of some help, and just helping us understand better how to talk about this. And this is why I think some of the work you heard from this panel is especially interesting. I've found in teaching law students now for 8 or 9 years about some of the findings of the implicit social cognition literature, that if I begin talking about the experiments that involve stereotypes about age, that the conversation is fairly relaxed, because I'm usually the only old person in the room. And there's not the same sort of stigma against ageist, if that's a term, as there is against racist. And once people understand or sort of buy into the mechanisms at that level, they find it a lot easier then to begin to talk about race or gender or other kinds of discrimination. So I'm running out of time. So I guess my main goal today is to encourage the scientists among us to see whether some of those intuitions are correct, and to help us better understand not just the stereotyping around race and the biases that affect the targets of bias, but basically how our understanding of people who we, in settings like this, laugh at and just sort of assume away, but for many of them we actually have to win some hearts and minds if we're going to do things like improve California employment discrimination, housing discrimination law. Thank you.
So as promised, I'm going to ask our panelists to engage each other. Do you have a question for each other, a comment? Denise.
Evan, when I was hearing you talking about your studies on the children and the time that they developed this, avoided talking about race, I'm just wondering if that means that within black and white families, certainly there's differences in socialization about talking about race, with the idea that black families just grow up talking about it. So does this suggest that it's important for white families then to talk about it before your kids turn to age 10?
Well,
that critical moment?
it's interesting because there's two general intuitions or beliefs among the white parents that we talk to. One is that by talking about race, they're somehow going to poison their children and they'll become racists. This notion that if they don't bring up these racial distinctions, then their children will never notice them, and you can sort of nip it in the bud in that sense. Again, I think that it's clearly this is misguided, but I think a lot of colorblindness for lay audiences, on the surface, there's something very appealing about colorblindness, right? There's this notion this is the way that things ought to work in this sort of utopian society. The question is, while it may be sort of an ethos well suited to guide behavior in a society liberated of these injustices, that endorsing it prematurely sort of warrants skepticism. And I think that parents need to be sort of reassured that children, again, are seeing these differences well before the age of 10. Moreover, the second point is that parents have these intuitions that, particularly among whites, race is not relevant. Why would a white parent? They say, why would we talk about race? It's not really relevant to our family or to our environment. And again, this is probably also a key notion that is sort of at the core of their children's developing struggles with dealing with this. Like, at a very simple level, it doesn't take a scientist to understand that if you're not going to talk to your kids about these issues at all, when they find themselves in situations where they may have to consider race, they sort of don't really know what to do, and they sort of take maybe a path of what they see as least resistance and pretend that they don't even see it.
And I think they kind of do know what to do, and that is whisper about it.
Well, you're right.
Because of role models they've seen as growing up, that when your parents or grandparents or whoever are whispering about race, or that teaches you that that's the way to.
No, and I think it's a good point. I think children and adults are, when they leave these studies, they're not upset. In fact, if anything, they sort of give us that nod, like, you passed your test, huh? Like, they truly believe this is the socially, culturally sensitive way to sort of navigate these situations. And so I think that speaks to that.
Anyone else?
Well, since one of the things that I work in with Catherine here and some other folks is education, I wonder if anyone is using this research to think about middle school curriculum or grade school curriculum, or do we have any sense of, outside of the parental realm, whether there are ways to get folks to get children to see it a little more differently than, it's like we have sex education in the school because parents don't want to talk about sex, so maybe we could use that model.
I mean, I think it's slowly sort of gathering momentum among select audiences, but I don't know of any sort of larger scale program that's being implemented or even being talked about. I hate to end it sort of on a somber note, but I think that the positive note to take from this is that around 10 years of age is important. And we're not saying that everyone older than 10 is sort of a throwaway, but in planning for the future, 10 years of age is a point at which children see these distinctions but are still not really sure what to do with them, how to navigate these situations that are still very impressionable. And so I think that beginning these types of interventions at the end of elementary school is going to be sort of a really important step moving forward. Yeah.
I have one question, and then we'll start to take one. So one of the things that, and listening to this conversation, which is very interesting because it's sort of cutting it at very different levels, right? You sort of have people looking at it at what might be called sort of the operational level. Kevin is sort of trying to figure out how does one operationalize colorblindness, and Evan and Denise, among others, are telling us about the impossibility of colorblindness as a sort of psychological phenomenon. Gary is engaged in this project of trying to restructure state anti-discrimination law against what Neil is telling us is a backdrop of sort of colorblind constitutionalism on the one hand and a private right to discriminate on the other. The instantiation of anti-discrimination law up against a state constitution that says pay no attention to race, which turns out to be difficult, if not impossible, to operationalize. So I'm really interested to see, for example, Gary, thinking about what Neil has to say about the private right to discriminate, what might a restructuring of anti-discrimination law offer if one wanted to chip away at that edifice?
Well, I don't think we want to extend Prop 209 too far. It's not a defense to employment discrimination. It's not a defense to housing discrimination across, in California, at least in terms of the numbers of categories that have, that are protected categories, is quite elaborate. It's, at least on the level of what's in the statutes, it looks like, there's a lot there. The question is, how do you either enforce that law or change that law so that behavior changes, so that discrimination is much less prevalent? So I don't, and fortunately, we're not talking about constitutionalism. We're talking about the California State Legislature. The Speaker of the Assembly is an African-American woman who's very sophisticated on these issues and already understands how things work. So we're not talking about Justice Roberts here.
Right.
So I think there are possibilities for moving at a statutory level, at a state level, that are probably barred for a long time in the Supreme Court.
Anyone else? Okay, I'll take questions here. Daria.
My question is for Kevin, Neil, and you, Cheryl. And my question has to do with the definition of colorblind as a legal matter. And it seems to me that we should be taking advantage of the Supreme Court's insistence on defining race in a very narrow way, race in a formal way as skin color when deciding whether or not to use strict scrutiny, for example. And the language in Supreme Court decisions that basically said you can't use race as a proxy for other characteristics. And so, for example, Scalia says you can actually identify victims of discrimination and give them preferences. You just can't use race as a proxy for whether or not they've been victims of discrimination. And so I'm wondering, for example, if you put back up on the screen Obama's autobiography, this essay, you wouldn't necessarily need to take out the reference to race. You could simply say my mother's racial identity without necessarily violating that. I was ingratiating myself to the dominant majority. The tragic mulatto doesn't really identify him by race. It doesn't say Well, I suppose mulatto does, but...
I suppose, yeah.
But... what I'm suggesting is that that what's prohibited is a reference to one's membership in an underrepresented minority group, but not reference to those characteristics and traits that are correlated with that group, so long as one does not use race as a proxy, as a stand-in for that. And I understand that strategically, university lawyers don't want to make that argument because although maybe things have gotten so bad that they wouldn't be willing to make that argument now. They weren't willing to make that argument, say, 5 years ago. But again, it strikes me as a legal matter, if you're going to define colorblindness, use the Supreme Court's very narrow definitions of race to define what constitutes colorblind. It means colorblind, not blind to all the other characteristics, traits, experiences, demographic situations that are correlated to this.
I mean, I think you concluded by giving what becomes the functional definition. I mean, I think that, I guess I struggle with the basic question of this conference, what exactly will colorblindness mean? How is it defined in any particular context? And I guess within the admissions context, the Barack Obama essay example is the perfect one to show the ridiculousness. That's why I enjoy it so much, is you cannot read that without understanding the context of the race, of how race influenced the development of this spectacular young man. And in my view, that is not violative of the Constitution. In order to understand that somebody may have, within the context that he or she found him or herself, grew up and excelled in that context. And that can be correlated to race, and I think that the issue for a university lawyer in trying to keep a client on the side of legality is to not use race in and of itself as somehow creating the necessity or the expectation that there is a preference for or against a particular candidate. This candidate is white, therefore he or she faced no hardship, therefore I'm not going to take into any context whether they went to a low-performing school or grew up in poverty or grew up an orphan in a foster home, etc. I mean, that would be wrong. Just as looking at, in the context of an application for admission, you're looking at somebody who may have overcome hardship that may or may not be related to their racial or ethnic identity. But I think that the society we continue to live in and the research that we're hearing about, I'm so fascinated by, shows that it's just not irrelevant to who we are as people. And if we as an admissions, doing an admissions function, are trying to evaluate a person's qualities as an individual, ability to add to the intellectual and emotional community of the university, you can't ignore the fact that they may come with different racial and ethnic backgrounds.
Okay. This is going to be a slightly disjointed sort of set of thoughts. What I'm currently working on, in terms of my own research, has been racing computer games and the notion of racial pleasure. And so if you're familiar with Anthony Farley's work, The Black Body as Fetish Object, the title by itself says a great deal about the questions of pleasure that go out in the consumption of race. And to the extent that this is an important phenomenon, that this is an area of consideration in terms of race in which empirical testing actually is clearly available. And I was reminded of there's a literature on stigma in the law reviews, as well as in, I'm told, in the social science, developing about the notions of stigma. That's an aspect of pleasure and disappointment and all those other kinds of psychological notions that are involved. But the place that this is to responding to Daria, the reason this becomes really complex is that once we are in the domain of racial pleasure and we are trying to investigate in terms of legal discussions, we leave the area of our traditional the familiar terrain of Title VII and equal protection and the Anti-Discrimination Model, and we end up in the First Amendment and freedom of expression with a whole different set of legal considerations as to what is involved in pleasure and disappointment. And racial pleasure operates in really strange ways, right? So those old photographs of lynchings and clear racial pleasure at watching a black body be lynched is one kind of extreme violent racial pleasure. But there's also, to use our example, Obama, right? So just close on two examples of racial pleasure, and I have no idea where they fit into the ability to test. One is Obama plays basketball. Right? This is clear. There clearly is a racial pleasure, a racialized pleasure associated with that. Right? That this is a particular notion about that there's a secret. That's secret. It's not secret. There's an identification that takes place. Because I remember the first time I saw those clips of him playing basketball in high school, I was ecstatic. I thought that was such a cool thing for a presidential candidate. And the other Obama pleasure is among Asian Americans, there is the secret pleasure that he's really Asian American. Right? So this is a commentary. You look at that CV, Punahou High School, Hapa parents, and Harvard Law School. I know this person. This is a model minority affirmative action. There he is. It's the wrong guy, but it's still a secret pleasure. So, as I said, but it takes us into a different body of law. So I think that just in terms of trying to understand the legal dimensions, there is a law. There is a legal terrain in which this is examined, but it's not Title VII. It's not the Anti-Discrimination Model. And so it's like really complicated and difficult to figure out at this point.
Okay, let's see. Carmina.
Thank you all for coming here to talk about race in the colorblind space. I was wondering if you could reflect on what race looks like in a post-racial space. Is a post-racial space synonymous with a colorblind space, or is it better or worse? And this question is for all of you. I have another question. What's it like for children to grow up in what's being called a post-racial world? And is there room for civil rights lawyers to use this post-racial buzzword in the name of good and try to apply it to anti-discrimination litigation? So anyone can answer. Including Professor Harris.
Not fair, Carmina.
Can't simply say this next year's conference.
I don't think there's any way to make any progress without having more honesty and acceptance of what the actual social facts are, as they're both understood in the lab and as experienced by people. So I actually think that anything that diverts us from understanding what was actually going on is a drag on the ability to make progress. So there may be some people who have some judo moves I don't know about, but I'm kind of like a straight ahead, like let's bowl them over kind of person. But
Let me just
Please jump in.
Well, I just was going to clarify, by post-racial, you mean sort of we've gotten past it? It doesn't
I
mean anything?
that to you because I feel like as a student, was always grappling with trying to understand colorblindness, but now it seems like everybody, the media was saying with the triumph of the Obama administration, they declared a post-racial era. So I wonder how critical race theorists and even civil rights lawyers deal with this what people are calling post-racial era, but when things like racism and discrimination obviously still exist and will continue to exist, just how to deal with it.
Yeah, well, I think that, this might be one way to look at it, and people might disagree, but it sounds like to be colorblind means that race shouldn't matter, it's not supposed to matter, maybe, or this post-racial, it doesn't really. We've gotten past that, and those things don't matter anymore. To social psychologists, it's hard to think about that post-racial ideal world, because all the research kind of suggests that as soon as we see that there's differences between social objects, we immediately start differentiating them. The ones within a category start to seem more alike, and then we also emphasize between group differences. And all that sort of leads to the stereotyping, and then down the road to prejudice and discrimination. So it's hard to imagine this, just if that's our cognitive response to looking at an array of social objects, to immediately start categorizing them, that we could ever stop that process from happening. I suppose that one could reduce the stigma around race, and maybe that could could reduce the likelihood of people going from automatic categorization all the way down to prejudice and discrimination. That seems not undoable.
I think, Carmina, what you're marking, and it is remarkable, is something of, we're in a moment of realignment and shift. And I think that the ideological marking of colorblindness may be yielding to something called post-racialism, which may have some of the same effects that the social psychologist and others are marking. But I think it's also made possible and enabled by the political moment in which Obama is elected as an act of post-racialism, right? There's no way to elect Obama in a colorblind context. There's only a way to elect him in a post-racial context, and his race then becomes, to use Neil's word, a pleasure to be consumed in the sense that it is a marking of our transition and our progression. In other words, Obama cannot do that work as a white man, right? He can only do, and I'm not talking about him intentionally, I'm talking about him symbolically. Lord knows the man has enough work to do. So I'm just saying that symbolically he functions in a particular way, and that may, I mean, I don't know what that means, but I feel you, is what I'm saying. I think it is a moment in which we're sort of shifting in terms of the terminology, although the effects and the consequences and what this looks like may in some ways have deep continuities.
Let me throw off this is literally off the top of my head model, the sex education model. So you can have sex education which is scientized, which is therefore insulated from and separated from the discussions about teenage pregnancy. Mm-hmm. And so by compartmentalizing the sex education into a science class, it's a different model and a different frame in which to discuss it, as opposed to teenage pregnancy or welfare queens or any of the other models. So if we can, post-racial, instead of having a single vision of race or what race means under a colorblind model, open the differences up, then we can have a race ed class for pre-9 and 10-year-olds, as Evan's model suggests, in which we talk about the scientific approach to racial education and separate it off from, as in the sex ed model, discussions of sexuality, queer theory, sexual orientation, male-female, and everything else in some fashion. So it's a suggestion that there are possible models for compartmentalized distinct educational models, or separate, as long once we get past the one race means one thing and colorblind means one thing, that clearly has to be opened up.
Kim.
I first want to say, to be at ground zero and to hear the General Counsel say Prop 209 didn't necessarily make me do it, that's heartening. And it connects into work that I've been doing for the last 7 years. Which is, at first I was looking at Prop 209, and unfortunately that became a study in the genre of anti-affirmative action law, because in the course of my study we gathered now 4. And so my question is directed at you, Kevin, which is moving and taking on that question, because that is what prompted me to look at this issue, of what actually does Prop 209 make you do versus the other components which an institution still has the discretion to, what actively the university still has the discretion to do under Prop 209. Now, what I have to have a little another asterisk to is that certainly the California courts have construed Prop 209. So what has made my project, I guess, broader is that we have new states joining California, that their state courts will indeed have to interpret what their anti-affirmative action provisions mean. And so I understand that your answer might differ from, let's say, Michigan's answer or Nebraska, because those institutions will be operating in a realm where the law hasn't been interpreted yet. But what I want to say, I guess, at ground zero and at a conference about race in a colorblind space, is that my understanding, and I'm
It prohibits discrimination. Now again, there is the issue of how the California Supreme Court have interpreted that. But as the institutions who sit still in control of making admissions decisions, how that fact, the fact that the laws themselves do not require colorblindness, and what role the institution can play in illuminating that fact to a ground zero community that seems to presume that Prop 209 requires colorblindness. I contend it does not.
The short answer is that's a work in progress. Having been here for 12 months, I find it was disconcerting to me the number of offices I'd go into, and people would say that they weren't even sure they were allowed to keep statistics as to the numbers of women or minorities hired or in the candidate pool. And my basic response was to say, how on earth do you know that you're not violating the law if you don't know who you're hiring and whether they are appropriately representing the world in which you are trying to work and make hiring decisions. So narrowly defined, what doesn't the university do anymore that I think Prop 209 does, in fact, forbid it from doing? There are no scholarships available using university money that the qualification for which is expressly race or ethnic driven, except legacy scholarships, which do still exist, those that were funded before the passage of Prop 209. And it means that we don't have the luxury or excuse, I would actually argue, of engaging in a brain-dead vision of affirmative action in which you continue to value an SAT score of X as being, a bar, and then creating something that is 80% of X and saying that if you're African American or Latino, then you can get in with that lower, with that less merit. And so I think that you end up, not having the sort of mathematical brain deadness of an affirmative action program that may have existed. And I don't know. I don't mean to characterize UCLA's former program because I actually don't even know what it was pre-209. But I think what it does, let me be very clear, I agree with you, it does not require colorblindness. It requires one not to establish a preference or discrimination against on the basis of race or ethnicity. And it is the business of trying to define how one makes official decisions within that context that can value, recognize, respect race in a way that doesn't violate the law, and I absolutely think it's possible. And that's it's a constant conversation around this campus as to how one does that. But by and large, it's a narrow definition of where dollars get spent and where lines get drawn at this point.
Okay, Josh. I'm sorry. This will be the last question. I've been informed. So make it good, Josh.
Well, I guess, in your discussions, especially Blazey's discussions, I'm hearing a kind of undertone or little references to the other theory of racial discrimination in Title VII, the discriminatory theory, coming in and out. I just want to flesh that out a little bit more. Given that there is now a movement to use this underutilized theory of discrimination in economic context among community lawyers, and seeing that happening, I do have some concerns or reservations about using the model. I'm just going to see what your thoughts are on that. Because, as you mentioned, there may be a lot of diagnosis going on, but not a lot of treatment. Discriminatory theory does have diagnosis and treatment built in. It's a specific model of it, right? Identify the effect. And treatment is any aspect of you that does not create a right? So I just want to hear your thoughts.
Well, I do think it has a lot of possibility in the class action context. But the vast range, looking at, the data set we have on discrimination complaints is 230,000 complaints, of which only a tiny fraction would be amenable to that. These are instances of individual acts of discrimination. You could argue that, people shouldn't be worried about that, but that's the ground on which discrimination is experienced, so we really can't ignore that. So we've been more focused on that sort of setting, or the setting of alternative remedies that would require institutional organizational changes, and that's where it does begin to blend into the kind of remedies you get into disparate impact case. I don't know if that answers your question or not.
Okay. Any other comments? I want to thank the panelists and all of you. 10-minute break and resume in this room at 3:30.